Welcome, this is Chandru. Thank you for coming here.
Thank
You
you.
are well known to the Kerala society, particularly after the releasing of Jai Bhim. That
Thank
is
you.
true, it has shown a very small part of your activities, like activities as a lawyer and activist. And after your retirement, you are seriously involved in several issues, the protecting the secular fabric of the country and the constitutional basic structures of our constitution. And thank you for coming to
Thank
state
you.
of Kerala.
Thank you for welcoming. Thank you.
State of Tamil Nadu had witnessed several social reforms movements, well-known social reformers like Kerala. But in Kerala, there is a continuation of these agitations by under the leadership of communist movement. Hmm. Then in Tamil Nadu, after these long struggles, I read in your book, that is JB, that you gave me during that function. We were together at
Yeah, yeah.
Noels, that the statues of Ambedkar were protected with iron grills and kept under lock and key, even in the premises of the High Court of Madras. That is a reality now also after all these struggles, these caste divisions and these type of hate things
One
are
major
happening.
reason is that in 1977, when several non-Congress governments came to power, and DMK also catch power in this Tamil Nadu, the party initially took a correct view on the anti-Congress front, but more of a class issues and less of a social issues. The concern of social issues seem to be monopolized by the Dravidian parties, less of the Communist Party. Communist parties were always said they are only class interests and not a caste is never an issue. So it took a long time to retrace and then find out how much caste becomes a institutionalized form of oppression and how much it is also correlated to class and caste. I think now, in the 20th century, the old deficiencies have been set right, and the party is more concerned on literature, women, gender issues, on caste issues. I think there is more, the presence of the party is felt more now. It's also a historical mistake that we have not taken social issues in a bigger sense, more concerned with the problem of trade unions and workers' rights, and within that, how much caste plays a role, we have failed to see it. I think those mistakes have been rectified now.
Not
There is a
actually,
greater scope for the growth.
but actually at the beginning you have mentioned the contributions of the communist movement in the social reforms movement in Tamil Nadu also. In Kerala also we could see in the involvement of communist movement in all social reform movement of the state of Kerala. But that is true in our political line, these social and economical issues clubbed together within the last 1.5 decades. That is true. But my question is, after all these agitations, this division is widening in state of Tamil Nadu and other parts of the country.
One good thing that has happened is that the consolidation of the Dravidian movement and the ideology, to some extent, stopped the saffronization of the politics, and they are not able to do much higher role in the Tamil Nadu state. But what is the deficiency today, which I could see, the fight against saffronization is not very ideologically crystallized. So it has got a different groups like Tamil nationalist group, then the Dravidian parties of anti-atheist groups and so many. So the consolidation of all this to have a single point, a program of the Hindutva advancement, that is lacking. Therefore, the Hindutva forces are able to make use of this contradiction. And till now, there has been no greater attack against the minorities. The Dravidian parties also sided with the minorities to protect their interests. Now, the conscious attempt of the BJP government at Delhi and the small presence of their party in the Tamil Nadu has now trying to create so many destabilizing issues. And using the office of governor is another issue where the governor virtually becomes a press, Sanchalak, Pracharak. He now says Sanatanama is good. Then he says that secularism has got no clear meaning in the constitution. Having taken the oath in the constitution, he speaks against the very constitution itself. In fact, in one speech he made, he said that secularism is not properly defined. But you know, the Supreme Court in Bommai case has clearly laid down what is secularism means. Therefore, this attempt of using every opportunity, one area is the area relating to secularism. The second area is using the educational institution, like being the chancellor. He was now trying to do many things like what the Kerala governor is doing, not accepting recommendation of the search committee, then trying to give extension on his own and refusing extension in some cases where he doesn't feel. In fact, I saw here there is one post of a lecturer in Kannur. He terminated the service. The similar thing had happening. So there has been a conscious attempt to capture institutions not just in the administrative capacity but also in the content wise. Today, rewriting textbooks and deleting textbooks from the syllabus and devaluing the academic council role. I think these are all stage managed by Center. The Ministry of Human Resources plays the bigger role in this matter, and governors are used as virtually an agent of the Center.
Actually, Ambedkar himself made a remarks in the Constituent Assembly that the post of governor is only an ornamental post. But there are some grey areas in the Constitution.
There are two things. One is that the governor under the 1935 Act had a greater power because it is a colonial government. But when the same post is sought to be created, assurances have been given in the debates that he'll be a sage advice he'll be giving. But here he has become a party propagandist, and that is, I never conceived anywhere that way. And I also saw that the least qualification that is prescribed in the constitution is for the post of governor.
Yes.
All you got to do is only a 35-year-old man, that's all, man or a woman. And then the choice of sending a particular person is something which is for some other reason that Congress contributed to this in a bigger way.
In 1959, they had dismissed the government of Kerala, the EMS government, using the report of the governor at that time.
There are, see, the difference between 57 and 77 are two different things. In 57, a report was obtained and the government was dismissed. Now, in 77, without obtaining a report itself, they dismissed. Therefore, the Congress consolidated the governor post contrary to the constitutional values that has been built in the... Now, what the Congress did, Janata Party also did the same thing. Janata Party 77, Indira Gandhi in 80, same. So, both the central ruling party consolidating the power from the state to the center. The amendment made in the 42nd amendment, taking several powers and vests with the concurrent, is virtually a centrifugal force where the center becomes all powerful. And secondly, whatever used by Congress become precedent for the Janata Party to do this. BJP is now saying the same thing. We did not do anything which they have not done it. So the undemocratic attitude of Congress and the fascist attitude of BJP, there is no difference at all in the operating the constitutional mechanism, and the greater emphasis on the post of governor. Now the governor, for example, in Tamil Nadu, all the bills sent by the legislature assembly, there are 21 bills he is sitting over it. When somebody asked, am I a postman, he said, I'll have to look into it. How long it will take for you to take a legal advice? Maybe a week or time or 2 weeks time. Now, last 6-7 months, he has not signed any of these bills, and therefore, some kind of a constitutional deadlock is being created for no reason. So I said in one article I wrote that you may not have postman, but even a postman, if he doesn't deliver letters, he has to action be taken, and you should send up the governor for this out of this. Because in the case of remission in 363, he has said that send it to the president, and Supreme Court told, you are not a postman to send it to them. You should have taken it to the
a remarkable observation of the apex court.
Despite
And
criticism,
that judgment, the Supreme Court said, you are not a postman.
Supreme Court said
You
you
are
are not
not a postman. You please send back to the.
So they
cabinet
themselves gave the
office.
relief, relieved him of that. So more today we find that the post of governor has become devalued in a sense that it is not mere head of state, but it is also an active opposition where they are not in power. Where they are in power, he also collaborates with the local government. Similar thing I also see happens
But as
here.
per the constitution, the post of governor, they are saying some protection. The actions of the governor and the president cannot be questioned in the court. But recently, I think in a need bill.
That is true. The state of Rajasthan to some extent was diluted in Bommai's case. But as Soli Sorabji said, it has to be kept in archives because the decision to dissolve a state assembly, there is no prior consent from the parliament. So he says that should be the correct position, that if you want to dismiss a government on the ground that they have lost the will of the people, majority support of the people, then the consent should be before and not afterwards. Now what is called is only a ratification. So he said, Bommai, we expected a wider
Interpretation.
So the question today will be analyzing how much of the federal structure it has been completely made into a union structure now. Now it looks as if we'll have to, even Soli Sorabji says it has to be seen by another bench. So it can't be left to the judiciary alone. It should be a political decision to have a true federal government. And
Actually, in this need bill case, High Court of Madras, they have made some observation. In extraordinary situation, the court can act on extraordinary steps.
that is true. That one thing is that I am only saying, if Bommai is by 9 judge, you can't have 11 judge and 13 judge to reconsider. It should be a political will of the people to say, like what Annadurai said in 60s, when a goat need not have a beard, why should the state must have a governor? And it's like an appendix, which you can cut it off and throw it off. So the Rajamanar committee and Sarkaria committee has really
And recently
recommended.
the Punji.
Yeah, they said that, though they did not say an elected governor, but they said the state must have a say in the matter of who is the governor.
The elected government, the issue had raised in the Constituent Assembly debate.
Correct.
Then Ambedkar told, this is an ornamental position, no powers. Nobody is ready to contest in this election. That was the observation
that's
of
true, that's
Ambedkar at that time. But that is true now, central government is
If after
utilizing.
72 years of the working of the constitution, you will find that there is more centralization through the court verdicts. The court unconsciously plays the role of supporting the transfer of power from state to center. So virtually every state has become a vassal state to the center, begging for more funds and things like that. A glorified municipality. This was never contemplated in those times. Actually, the provincial assemblies had a greater power than what we have today. But then assuring that the state will have their own power under the list 2. But we find the list 3 getting increased, not just by a constitutional amendment, even by central legislation like real estate law, rent control law, and teacher education laws. Everything made into a central law. Then a bureaucratic central setup decides every matter which is otherwise open to the state to decide. This is a very unfortunate situation.
You have mentioned about the education earlier. Actually, it was in the state list. Thereafter, after constitutional
25
amendment.
becomes central list.
Yeah.
Now, more than that, after the 1984, when more of the self-financing education was thought of, Supreme Court gave a very startling explanation that in entry 66, higher education, standards, higher standard, it's only solely the center. Therefore, you find now, whether it is engineering or teacher education or nursery council or medical, everything is center now. Now Tamil Nadu government is fighting this NEET examination. Whether it's right or wrong is another thing. But the governor is sitting over the bill for so many months together.
But as per the entry 32 of the state list, the incorporation of the universities is under the jurisdiction of the state legislature. And Parliament has no
Even this
legislative
argument that
competency.
the governor alone can be the chancellor can never be accepted. For example, in many of the law schools, the chancellors are chief justices or the senior Supreme Court judges. Therefore, there is never a convention. If there was a convention, convention has been broken in the last 10 years. Therefore, he is sitting over that bill also.
Actually, the governor is working on the directions of the power included from the constitution itself. But the chancellor is working on the power given by an act passed by the state legislature.
Correct.
That these two positions are entirely different. One is a constitutional position. The chancellor is the position
Actually, the
got by
first
the
university,
state
Madras
acts.
University, which was established in 1929, the chancellor was made as a visitor to the English president. His role is a supervisory role and not as an active participant. And even directly he cannot order an inquiry. But we find the other way around. Every decision taken in the syndicate or the academic council or the executive council, he tries to put his own ideas, his own people there. That is never thought of.
Then this federal structure actually is facing serious dangers during this BJP period. It is there in the Congress regime also, but that tendency to centralizing all powers is increasing during this period.
Actually, when the planning commission was conceived during the Nehru's days, there was opposition that you cannot make every planning into centralized planning. So there was some explanation given. Now this new government has abolished even the planning commission and have their own ideas of distributing resources. So virtually the states have been made as a beggars to go and stand for some financial assistance. So every scheme is now given the name of some BJP leader and then circulated to state. The one way of consolidating the political powers at the cost of a federal structure. That's one reason. Secondly, even at the time of conceiving of the constitution, the financial mobilization, major powers are given to the center and not to the state. Whereas the collection mechanism is only with the state. Therefore, this is something which...
At that time, there was an
in fact, the
argument.
EMS ministry which raised
No,
the
in the
issue.
Constituent Assembly, there was an argument. There should be a ceiling for state governments for the collection of state tax.
That's true.
At that time, Ambedkar had replied that now all power, most of the powers for tax collection is with the central government.
Like
And it
the
is not,
enactment of
justice-
GST is again now made everything to the center.
Yeah,
That's
but the Supreme Court verdict with regard to the GST Council, it is not a mandatory mechanism, but de facto the same thing is happening.
when EMS came to power second time in 1967, that Raj committee made a recommendation of financial
K. Raj.
reallocation.
Yeah.
And Jodip also followed it with several other demands. I think time has come to revive more of a state autonomy in the sense of greater powers to the state and lesser to the center. Unless the over centralization is stopped, the saffronization has become complete, then it becomes a fascist state. Nothing can be done on this matter.
Then in Tamil Nadu also, the attempt to centralize the powers with the governor and to take and the initiatives to intervene in the activities of the universities, as per your opinion, is a planned move for saffronization of education.
There also one problem comes in because slowly we also find that the universities, state universities become more bureaucratized universities. Several secretaries of government are ex officio members. So there are little academic autonomy. I think either the UGC or the state government should discuss this issue. There is less of a participation of the academic staff and more of the administrative staff in the university setup. That there are several changes has to be done. One such change is that more of an academic activity and less of the...
Now in the state of Kerala, we have constituted several committees.
Okay.
Now the second government is focusing on higher education, improve the quality of higher education, making Kerala as a hub for higher education. And we are trying to develop some of the colleges and universities on an international level. In these committee reports, they have mentioned to restructuring the existing
In fact,
mechanism.
we also have a enactment, Tamil Nadu State Council for Higher Education, where it combines all the universities for a centralized advisory role. Now the governor, contrary to this law, he convenes meeting of Vice Chancellor in the Raj Bhavan and gives his own advice. You start with the national education policy. When the state government is solidly opposing that policy and say we should have our own policy. Now, several issues, there is a direct confrontation, but then the issues are slowly hotting up to the extent where they are asking for recall of the governor. I think same thing should be there in Kerala also. It's not the mere recall. The very institution itself is now centralized to some extent. He behaves like a party agent of that central ruling party. That should stop. That is,
There are certain concrete recommendation by Sakaria Commission
same, yeah.
with regard to the appointment of governor, the qualification of governor. The governor
Another
should
thing
be
is that sitting in
from a
Raj
panel
Bhavan
of
and trying to communalize the politics, trying to give a legitimacy to the saffron politics, where the secularism and the principles of treating all religious communities equally, that is slowly disappearing. That's another thing where, having taken the oath in the name of secularism, you try to question the very concept of secularism. Recently, Subramani Swamy has filed a case in Supreme Court that word should be removed from preamble. It is not, it's only an addition in 76. There are enough indication in the constitution.
It was there from the beginning.
So this is another area where we have to be seriously concerned that how to protect socialism and secularism as two important goal for the constitution. And the issue has to be revived, the content of secularism. Now that has been well defined in Bommai's case. But then people start questioning things. This is not the socialism. In fact, the governor of Tamil Nadu was heard saying that there is no dharma in the Indian constitution. I don't know what he means by that. And there is a codified law, and the law is adopted by the majority. It has to be enforced. Where is the question of dharma which comes in? This is something which is unheard of. And I find there are two developments take place. Openly defying the constitution, having taken the oath under the constitution. Now there is a meeting of Hindu sannyasis in Varanasi, who are having a second constitution.
No draft.
Hindu constitution. This is like in Bangladesh, in Article 7A of the Bangladesh constitution. If anybody denigrates or disrespect or negates the constitution, you can give death penalty. We don't have that. But then what is happening today is a danger to the constitutional democracy, which is...
Then I think one of the primary responsibility in the contemporary, political responsibility in the contemporary India, that is to protect the constitution.
No, the greater danger comes is the seal of approval given by judiciary. You saw in the Ram Janmabhoomi case. It is not the law.
And
it's a faith,
giving more power
majoritarian
to the ED.
faith which takes away the property. And then emboldened by that kind of a ruling, even the munsifs and district judges in Varanasi and Mathura, they start reopening contrary to the law of 1991, Places of Worship Act. Therefore, today there is a saffronization is not in the polity alone, it's also in the judiciary, slowly. I could also say that when the National Judicial Appointment Commission was struck down, BJP did not want to bring another amendment because they find collegium they can bargain more, better than NJAC. Therefore, today...
But in the constitution, you could not find a word, collegium. Nowhere in the constitution.
It's a judge-made law.
Yeah.
Now there is no attempt to change it because you can bargain with the collegium than with any NJAC.
Yes.
I always found...
Recently, Justice Shah wrote a lengthy article in Hindu, the Chief Justice under Modi's regime, particularly the actions of two CJI, the former CJI.
Under the
Ranjan Gogoi.
Under the third judge's case also, they said we are not devaluing the state government's suggestion, but the primacy should be the judiciary. But what really happens is, I find, whether it's in Kerala or West Bengal, where there has been, for a long term, there has been a left government. the suggestion put forth by the government for any judgeship is always rejected on political reasons. The reason is that the judicial selection is also controlled to some extent by the central government itself, and therefore in the process of selection you are also having an ideological filter. This is very dangerous. And,
as per our constitution, all these organs are independent within their arena, that is executive, legislature and judiciary. Now there is a tendency to cementing other organs with the executive, like executive legislature, executive judiciary or executive
in fact, I
media.
call that as a cross-border terrorism. When Monroe says that you must have a defined powers and act within the power, everybody try to attempt to take over the power, and judiciary plays a bigger role in that. And the state high courts are much more now slowly getting into the process. At least Supreme Court has some well-laid norms, but state high courts have taken, even every department of the government, they start running it on their own. Stay this, stay that. For example, in Andhra, they were giving house sites to women. That is permissible because there is no gender bias in that. They thought men may sell the house, sell the plot, therefore give it to the women. There has been tried even in Provident Fund, several places that have been done like that. But then the Andhra High Court stayed the whole program. How is that they are concerned about suddenly about gender bias on a reverse discrimination? I think time has come to question the accountability and the approach of the high courts also. One of the institutions which is hardly ever explored is the judiciary. But so much money is being spent on them, and what is in return that these institutions are standing for? Therefore, the accountability of the judiciary is one of the major. Actually, the judicial accountability bill is still pending in the parliament. They are not willing to pass that. Since we are not accountable, you also be not accountable. That seems to be the attitude.
You have a very healthy and memorable relationship with the Justice V.R. Krishnaiyer.
Yes, that's true.
He had always mentioning about the preamble of the Constitution,
Yes.
secularism and socialism. Actually, the contribution of Justice Krishnaiyer or Justice Bhagavati or Justice Venkatachalaya, this new jurisdiction of this PLI, public interest litigations, that character of the judiciary has been changed during this period.
That is why Bhagavati called it as a social action litigation. That is, communities which cannot come to court for want of legal assistance or economic assistance. Now, the bill today is something different now. It has gone to a different area where even monopoly houses can fight through bill, one against the other. Corporate entities are fighting through surrogate litigation. So, there are many negative trend in the bill. The bill, though they try to define that it is not a public interest, it is not a vested interest, but then actually the time spent by the court on bill is much higher than other cases. And the original concept for which bill was evolved, that give exemption from procedure, exemption from court fee, and then allow a representative litigation to come in, all that is now gone. So you can set up one person even against a government, elected government, even against a policy made by the government can be set at naught by some litigation, if only some judges are thinking. Now I find in Madras High Court, the major task is that retrieving temples from the governmental control. Now this is one agenda which BJP is completely instigating through from behind the scene. But what is the interest of judges to be so concerned about retrieving temple when there are so many other issues are there? Every 10 cases, 6-7 cases are only relating to temple property. And there are many things. For example, recently Madras High Court passed an order. If you don't complete the eviction, we will call the paramilitary force. Andhra Pradesh High Court said in one matter, if you don't file reply by tomorrow, we will recommend to President for a President rule. I don't know where our judiciary is going. There is less of accountability and more of
There,
self-interest.
then there should be a strong and unified movement to protect the federal structure of our constitution and secular fabric of our country. Hmm? A very broad
Now we
movement
have
is the
judges
need of the
selected
day.
not on the basis of any commitment to a larger cause of constitutional philosophy. They are just selected because, like what Romapal said, the Supreme Court judge, it has become a old boys club. 2 old boys are enough to take a third old boy. And the most secretive institution, because nobody knows why somebody is
The
selected.
credentials of the judges, there is no transparency, and also Angel syndrome. During my parliamentary days, while participating in the judicial accountability bill, I had mentioned at that time there is not a single judge belongs to SC community in the Apex Court. After the
That's why we
retirement of
find
the
among
then
the judges
CGI,
we have 2 types.
after
One,
the retirement of CGI Justice KG Balakrishnan.
yeah. We also now we have 2 types of judges. One is forward-looking judges, other is looking forward judges. So we have Sadasivam coming here as a governor. Ranjan Gogoi accepting some nominated. These are all condemned by BJP itself in the parliament. Arun Jaitley made a scathing attack about judges accepting such post-retirement.
Not only he had mentioned at that time, while he was in the post of opposition leader, not only they had tried to get some posters after retirement, the Supreme Court itself had created some posters
Yes.
for their retirement periods.
That is true.
It's national highway. There should be a committee under the leadership of
A retired judge
Supreme
or
Court judge for calculating the fee structure of self-financing institute. Normally, it is the profession of a chartered accountant or a cost accountant, but there should be a committee under the
In fact, I
leadership
can give
of
you
a
2
retired
examples,
high court
very
judge.
glaring example. Under the Right to Information Act, the Information Commissioner can be any person. Now suddenly one judgment is coming, only a retired judge can be posted, judicial person. Then they themselves felt very awkward, they removed that. The second was in the Legal Aid Service Authority. Crores of rupees are given for legal aid. A retired judge can be appointed under the act itself. Like P.N. Bhagwati was a father of the legal aid movement. At the time of retirement, he said, let me head the national legal aid movement. They said no. And Arjit Pasayad passed an order that all legal aid services should be headed by a sitting judge only, which is contrary to the parliament law itself. And today that is a law today.
Yes,
So the second judge becomes the legal aid chairman, goes in a second car, and then never in his life he would have even dealt with one single legal aid matter. How is that he is suitable to this post? Nobody knows. Ex officio he is made as a legal aid person. Now this is something contrary to the parliament law. You try to create some new niches for the judges. Even recent controversy on the Finance Act, whether the tribunal members should have 4-year or 3-year. All the tribunal appointments are completely stopped now. Today NCLT doesn't have a chairman at all.
Yes.
Whether it's 4 years, 3 years. Now issuing a public interest litigation and trying to dominate, saying this should be the law. If a tribunal chairman is there for 3 years or 4 years, it's immaterial.
Yes, yes.
But then this still goes on, this argument still goes on.
Only it is with the legislature.
That's true, yeah.
Depending upon the nature of the commission,
That's true.
the cases which they have deal.
This is a post-retirement benefit for the judiciary, that's all.
In your book, Jai Bhim, the forwards by Gopalakrishna Gandhi, he has mentioned that Justice Chandru is a phenomenon. Is it true?
That is, we'll have to sell ourselves only. I think it should not be left to some isolated example that there are more number of people should come. This kind of, at least post-retirement, they should spend their time for the people and not for their own office of profit. Another scandal is the arbitration scandal where they make tons of money.
Yes, yes.
And most public sector lose everything in this game. This outsourcing of the judiciary is another dangerous area where I find in the name of alternative dispute resolution, you try to push off some cases from the court itself. Now this is some dangerous situation because you take the case of check bouncing cases. It was a criminal law first, then it was a civil law, which was criminal law. Now they say it should go to Lok Adalat. The sheer number decides the forum. That can't be there. There must be justice surrendered to the parties. That is never never seems to be the attitude of the central government on this issue.
Okay, thank you for
Thank you.
spending time
Thanks,
with us
thanks
here.
for